What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Welcome back to the Zona Law podcast. I am Mark Zinman, one of the attorneys with Zona Law, and I'm joined here today by Scott Baluha, also one of the attorneys at the office. Scott, good to see you.
Good to see you as well. Good afternoon.
I should say good to see you, but I see him every day in the office, so it's still exciting to see him in the podcast studio. During the pandemic, right, we're talking from March 2020 all the way through basically November 2021. We gave a lot of podcasts, newsletters, information out for clients about all the changes during the pandemic. We're really trying to shift now back to why we created this podcast, which was for what purpose?
The core business here is really to make sure that we're providing excellent advice to on-site managers so that they can figure out how to better manage their day-to-day operations. Inevitably, there's situations that come up every day. You need to have advice about what to do with those, and that's why we're here.
Yeah, and really what I'd like to do is get back to the basics, right? Start from the beginning. So, you know, if you're first time coming into property management, it's a new property or you're a new manager, you can come here and we can kind of walk you through just the basics of what this business is. I don't know if anybody actually listens to the intro to our podcast, but it makes comment about providing staff training to keep the properties out of trouble. And that's what we want. Our whole goal is that clients follow the law, follow their remedies as they're provided, and it's better for everybody.
And it's a two-way street. There's rights and obligations for the tenants just as there are for landlords. And as a property manager, you're going to face daily challenges, hopefully not that often, but with non-payment of rent, with neighbors coming in and complaining about noise, with other situations that might pop up, and that's what we're here to help you with.
Yeah, and let me tell you, no question, noise complaints from one tenant against the next tenant, those are the hardest because those are the ones you're looking for proof. There are two people complaining, and you're, as the manager, stuck in the middle a lot of the time. So what we're going to do here, do a 3-part series on the evictions, which, again, evictions are never easy. We're sympathetic to what tenants go through. What a lot of people don't realize, though, an eviction is the only remedy a landlord has, right? Is there anything else they can do?
Yeah, for the most part, that you're correct. That's all that you can do in order to remedy certain issues. Now, if there's noise complaints or something else, there might be a process in place to be able to give notice and the person has an opportunity to cure. So that would be the first step. But then, short of that, eviction is where you have to go.
But that's the question, right? So the landlord serves, and let's say you have two tenants complaining against each other about, oh, you're partying all night, you're having people blasting the television. What do you do as a landlord?
Well, the first step is you're going to have the mindset of, if I have to be in front of a judge, what am I going to tell the judge to be able to support this claim? So I always say, a tenant, give me some evidence to support that this is happening. Take an audio recording, take a video recording. If I'm the manager, I'm also going to ask people that live nearby as well, because I want to hear from them if they're having the same issue that this particular resident that's coming in and telling me about the noise complaints.
Yeah, it's documenting everything. And then your right as a landlord is to serve a notice. And depending on the issue, and we'll go through all these issues, if the issue's not cured, then you're going to file an eviction. There is no other remedy that a landlord has. It's notice, and if the issue is not remedied, then you file an eviction. And so landlords' hands in a lot of ways are actually tied to the fact that they can only do the eviction. So let's go through, there's basically 4 different types of evictions you're going to be filing potentially as a landlord. Give me the first one.
First one, non-payment of rent. That's pretty straightforward. You got a non-payment of rent-related issue. You end up serving a 5-day notice. The 5-day notice gives the resident an opportunity for over those 5 days to pay the amounts that are owed, and then continue on with the lease agreement. As long as it's remedied, no problem.
Okay, so what you say, as long as it's remedied. So Arizona is what we call a cure state, right? So if tenant pays everything that's owed within the 5-day period, the rent and the late fees, you'll never even file the eviction. The case will be dismissed. And that is the hope. You serve a notice, the tenant comes into compliance, and you're never even in court.
Correct.
Potentially, though, you do have to file an eviction. Can a tenant then pay after court?
Well, up until the time that a judgment is entered, a tenant has an absolute right under Arizona law to pay everything that's owed. Now, if the eviction action has already been filed with the court and there's been court costs and attorney's fees that have been incurred, then not only would the tenant have to pay the past due rent, the late fees, they'd also have to pay the court costs and the attorney's fees in order to reinstate the lease agreement and get the case dismissed.
And a landlord has to take that. I've had clients in the past where they have other issues with the tenant and say, well, I don't want it, they're causing too much problems. And, well, the answer is you filed a non-payment of rent case. Arizona cure state, meaning they have an absolute right, the tenant does, to pay up until that moment of judgment and reinstate the lease, and the landlord has to accept it. Now, after judgment, which we'll talk about in another podcast, those rights change, and the landlord has discretion of whether or not they paid. But it really just comes down to serving the notice and then filing the eviction. So we'll go to the other three types of evictions that can be filed. But while we're here, let's talk about how do you serve a notice, whether it's any one of those kinds.
Well, what our office recommends is certified mail. Under the relevant statutes, you would have the ability to serve a certified mailing to the tenant, and then it's deemed received 5 days later. That's the most solid way to get service. Now, that doesn't mean it's the only way. You could also have hand delivery or any other method that's reasonably calculated to provide notice to the tenant. However, like I said, you want to take the most conservative route and go with, I know that it's going to be received even if the tenant doesn't pick it up after sending it via certified mail. It costs a couple extra bucks, and you have to add a few extra days onto the 5 days for that, but it's worth it in our opinion.
Yeah, and hand delivery is great as well, especially if you use a process server, so you can actually get an affidavit of service saying, hey, this is the person I served, this is the date and time, this is what they looked like. If you're doing it as, we've had tenants come in, where the manager's serving though, and the tenant just says, they lie, and they just say, nope, I never got that. The manager's like, well, I saw you, I put it in your hand. So those are the kind of the issues you want to be aware of. And that's why obviously a process server is good for that, or sending certified mail is guaranteed. And there's other ways that can be done as well. Like Scott's mentioning, that you just don't have that deemed received language to make it even that much stronger. So let's step back again then. We mentioned non-payment of rent. What's the next kind of notice that a landlord would serve?
The most common one is a non-compliance, and going back to what we were talking about before with excessive noise complaints, dogs being left not on a leash in the community, other similar types of issues like that. That's generally what you would use a non-compliance for. And in that circumstance, if it doesn't affect health and safety, the tenant would have 10 days to cure the non-compliance. But if it is a health and safety related issue, then they would have 5 days to cure. Now, what are some types of, how would you differentiate between a health and safety versus a regular non-compliance?
Me? I think bugs, right? I think infestation. I think problems that tenant cause that you're like, oh my God, that's about to start to infect the room next to them. That's probably a 5-day health and safety. I have seen those pictures, and I don't ever need to see any more in my entire life, of where managers go into the unit and you have pictures of the kitchen, you have pictures of the unit, and it's literally boxes stacked everywhere, cockroaches where there's, stuff all over the cabinets, food left open, and you're just like, I can't believe people live this way. That's a 5-day health and safety. On the other hand, a 10-day non-compliance is just general disturbance in the community, which would be, like Scott mentioned, unauthorized occupants, unauthorized pets, noises, partying, people running, just generally disturbing the community, causing problems. Those are the 10 days. And like non-payment, again, what that means, and this is a lot of confusion, which is that behavior can actually continue for 10 days. The eviction isn't filed until day 11 if the problem continues after that time period. Because the reason, if you boil it down to, think somebody has a girlfriend, girl lives in the property, she has a boyfriend. Boyfriend's not on the lease. Girlfriend says, hey, you can come live with me. He's living there. Landlord would serve them a 10-day notice for the boyfriend to be removed. So day 2, the boyfriend may still be there. Day 3, the boyfriend still may be there. Day 10 even, the boyfriend may still be there. But if he's there on day 11, then what happens?
Then that's the triggering event for the landlord to be able to file the eviction action. So it's incredibly important in those types of circumstances that you have good evidence to be able to support that that person is still residing there on the 11th day, because it's like a snapshot in time. On the first day that the notice is served, did that violation exist? On the 9th day and on the 10th day, did that violation exist? On the 11th day, did it still exist? And that's the way I always try to explain it to everybody, is that it's a snapshot at each of those individual time periods. And if it continues after the 10 days and you have proof of it, that's a great basis to file the eviction action.
And proof is everything. You're talking to attorneys, right? We're filing lawsuits. We need proof that we can take into court. That would be pictures with date stamps on them showing this was day 11, which happened to be, February 28th. And on that date, we saw them there in the morning, we saw them there in the night. We have pictures of their car. Or if it's because of disturbances, we have video recording of people screaming. And especially now, listen to this, managers. This is critical for you on site. If you're getting caught where two tenants are complaining about each other with noise complaints, I'm like, I never use this cliche, but we're in 2022 at this point. If somebody can't record what a disturbance is next door or above them, what the noise complaint is, or you see people in and out, they can't take a video on their phone or recording. I'm like, come on. We need the basic of evidence if we're going into court to make an allegation to remove somebody, because these are serious things.
Right, and that's not to say that is the exclusive. Sometimes there are circumstances in which you might not be able to get the recordings, but if you have several different residents that are complaining about the same thing, you have to verify with them, are you going to be willing to come to court to testify about how much of a disturbance this is causing for you? Because if it's something nebulous like pounding on a wall, sometimes you don't have enough time to record it. So it's not as though you're required to, but it's extremely helpful in this day and age when recording devices are so widely used that you should also push your residents to try to obtain that as well.
Yeah, and having your other residents that are prepared to come to court if the issue continues is critical as well. So we have non-payment we've talked about, non-compliance we've talked about. Next is the immediate. What is the immediate?
Well, before we move on to the immediate, let's say that a resident comes in and the issue is cured in the 10 days. But let's say a couple months later, the issue happens again. What do we do in that circumstance?
The second 10-day. I know I was unsure if we're going down this road, but I do appreciate you doing this because there's so much confusion with the second 10-day, which it really shouldn't be, but there is a lot. So this is critical information here. A first 10 days says you've got 10 days to fix this issue. Well, let's go back to the boyfriend-girlfriend situation. Maybe the girl says, boyfriend out, he's gone by day 9. Great. You don't file an eviction because they've cured. Next month, the tenant pays rent. They're back on track. Everything's going good. Maybe the month after that, they pay rent again. Month after that, the tenant comes back. The boyfriend comes back, excuse me. At that point, you can serve a second 10-day notice. That is a non-curable 10-day notice, meaning you got 10 days simply to vacate. You've done the exact same breach as before. And it's really what's critical for this is that you have the allegation that it's the same 10-day notice, same violation, and it's just within the same lease term. Meaning if you signed a new lease or you're month to month and it's a new lease, you can't do that. What people get confused a lot is you can't serve a second 10-day during the initial 10-day period, right?
Correct. Yes. So that's sometimes we get the question that, well, I saw the unauthorized occupant there on day 5. Can't I just serve a new notice? Well, no, you have to wait for the first 10-day notice to cure, see whether or not it cures, and then if it happened again the next month, then serve the second 10-day. Another thing I'd like to point out is all the non-compliances that we're talking about, and highlight this, and make sure that you find some way of tracking this in your system. But once you've served any type of non-compliance notice, you cannot accept rent. You must reject any attempts, because sometimes you'll get a non-compliance you'll send at the end of the month, and then rent is due during that 10-day window. You'll have to find a way to track it so that any rent that is received is rejected. Otherwise, you will have waived your right to move forward on that non-compliance.
Yeah, and let's be honest, partial payments is even a whole nother podcast that we will get to that as well. But yeah, if you accept money while there's an outstanding breach, you're waiving that breach. All right, so now let's jump to immediates. What's an immediate?
So if you're in handling your day-to-day operations and you think immediate, what does that mean? Generally, you're looking at severe property damage. You're looking at criminal acts. That's generally what immediates are reserved for. Threats of intimidation against the landlord, landlord's agents, or other residents. If you're calling the police, most likely it's going to be an immediate.
Yeah, if you're fearful for your safety, I mean, we've seen it all. I'm not kidding you. We've seen, tenants DUI, drunk through the property, ram the gate, hit 15 cars, and then park wrong into their own parking spot. That's an immediate. Coming into your office, screaming at you, threatening other residents. I mean, I saw one last week where a tenant wrote a 6-page email just threatening all the neighbors around them, threatening management. When that happens, you call the cops, you call the police, you make the police report. Hopefully they come out and take action based on those threats, because you have to assume those threats are credible and protect the safety. You file the eviction. So that's for the immediate. Any other thoughts on the immediates before I jump to non-renewals?
So how long does a tenant have in the situation that an immediate is served on the tenant for the tenant to remove themselves from the property?
Well, technically, I mean, there's no real time period. I mean, if you serve it, if you hand deliver it, theoretically, you can file the eviction the next day. And there's even an argument as well that you may not even have to wait because of, obviously, the severity of the situation. An immediate doesn't change, and we'll talk about it a bit in the second part of this podcast series. It doesn't change the actual court process. The immediate changes the notice time period and also how fast you can get a writ after you've got a judgment. But you still have the regular court process of filing a case, waiting about a week, and then coming back to court for that. So the last one we've got today is non-renewals. How does that come up?
So if you're in the term of a lease, let's say they signed January 1st, 2021, and the lease runs in most circumstances for a 12-month period, then the lease is going to end December 31st, 2021. You have to look at the specifics of your lease, but up until the date of the end of the term, there may be a 30 or 60-day notice that's required if you intend, as the landlord, to non-renew. Now, there may be numerous different reasons that you may want to non-renew, but under the Residential Landlord and Tenant Act, you don't have to give a reason. Sometimes it's we're doing renovations and upgrading the conditions in the property. That's really what you have to look at. Now, once you've finished the term and you're on a month-to-month, then you only have to give a 30-day notice in order to non-renew a tenant.
Yeah, and it's important to remember that tenants can give non-renewals as well, right? Tenant says, you know what, I want to be out at the end of March. Here's my notice. I'm leaving if they're month-to-month, or if your lease requires 60 days, obviously you have to comply with that as well. And if they don't move out, the landlord's remedy at that point, again, still comes back to the one thing that a landlord has a right to do, which is file an eviction. That's their right to get possession back. And like Scott mentioned, a lot of times it's not that they're even a problem. There's not necessarily even a breach. I mean, it's possible the landlord's just doing renovation, wants the unit back to fix up because they're the next one scheduled. You can pretty much non-renew for any reason as long as it's not discriminatory, as long as it's not retaliating. You serve the notice, that's it. And as Scott mentioned as well, you don't put your reason, except for under certain HUD programs, you don't put your reason in the notice. It's just not required under state law. So with all of those different types of notices you can serve, it comes down to the evidence. Obviously for the non-compliance, for the non-rule, it's just the non-rule, non-payment. It's just the documentation.
Correct. And one of the things that you'll be asked as soon as you refer a case over to your attorney's office is, well, what evidence do you have to support that? You got to make sure that you have your ducks in a row before that evidence goes over to the attorney's office, because you know that that's the first question that you're going to be asked, because that's usually the first weakness that we end up rejecting any notices that end up getting sent over to us, because it's just there's not enough there. Well, the resident told me. Well, we can't go off of that. We have to go off of, will the resident testify about it? Do they have personal knowledge about it? And more other specific legal requirements.
And you may not have intended it, but that is a perfect segue for us to finish here and leave that part of the evidence and what we're looking for court as part 2 of this series in really looking at the court process. So the first one, obviously, this is the notice, the pre-eviction. Number 2 is going to be on the evictions themselves, the hearings, the court process, and then number 3 will be the court post-judgment remedies and rights that both parties have at that point. So until part number 2 of this series, thank you for joining us on the Zona Law Podcast.